Welcome to the AIER's Authors Corners podcast. My name is Ethan Yang. I'll be your host today. And today we have an exciting guest, Timothy Sandefur from the Goldwater Institute, which is a very important public interest law firm in Arizona. Tim has been on the forefront of fighting for economic and civil liberties in the legal profession, and he is the author of the book, The Right to Earn a Living, which coincidentally is 11 years old, but has become very relevant in the times that we are today. So, Tim, it's great to have you.
Thanks for having me on.
Yeah, of course. So let's jump right into it. So to the average American, they're probably thinking, the right to earn a living, that's common sense, right? But in your book, you explain that this issue has been a really contentious one that goes all the way back to, you cite like England in the 1600s and all that kind of stuff. So can you take us through the history briefly when it comes to this quintessential right that we have?
Yeah, well, the legal history of the right to earn a living as protected by the law, as opposed to a philosophical issue, really traces back largely to the 17th century, Shakespeare's day, and to British disputes, or in the English common law, disputes over the government's authority to grant monopolies in certain trades to one business versus another. The classic case is called the case of the monopolies, or Darcy versus Allen, which involved a case where the Queen had granted a monopoly on the making and selling of playing cards in London. Only one person was allowed to make and sell playing cards in London. And another guy made and sold playing cards in London and got brought up on charges for it. And the question was whether that was legal or not. And the Court of Queen's Bench held that it was not lawful, that the Magna Carta's law of the land provision protects a person's right to earn a living without unreasonable government interference. And that largely wasn't the first case by any measure, but it was the most famous. And that launched this sort of series of decisions by English courts upholding the right of a subject to earn a living at a common occupation, as opposed to like a learned profession that you needed a license for. And those cases really formed the backdrop on which America's founding fathers relied. When they were writing the Constitution, the Declaration of Independence, and so forth, these were men who had studied law by reading those precedents, and particularly the work of Sir Edward Coke, who was the leading legal theorist of the day and was really the fountainhead of this idea that the unwritten English Constitution protects the right of a subject to earn a living. And the founding fathers basically took it for granted that everybody had this right. They refer to it in a lot of their literature. Objections to British monopolies were one of the leading causes of the American Revolution. Benjamin Franklin, Thomas Jefferson, and others complain about British trade restrictions. For example, it was illegal to manufacture things out of iron in the British colonies. You had to send the iron back to Britain to be made into retail goods and then shipped back to the British colonies to be sold here. And as Jefferson says, to finance not men but machines in the island of Great Britain. And of course, Adam Smith complains about monopolies in Wealth of Nations at the same time. So this idea that an individual has a fundamental right to use his or her skills to provide for himself and his family, that was really the backdrop on which the Constitution was written.
And you mentioned in your book, and this is a very important transition point where we obviously we know about civil rights, the right to free speech, the Fourth Amendment, that kind of stuff, and that's been robustly protected, essentially as long as we can remember. But economic rights, you point out that there's a big diversion from that, maybe in I believe it's like the 1900s in the Progressive era. So can you explain that discrepancy, that growing divide between our values, the courts valuing civil rights over economic rights?
Yeah, well, there's really sort of two stages in that, you could say, because by the end of the 19th century, let's say 1890s, the idea that the individual has a right to earn a living without unreasonable interference from the government there was a large consensus on that principle among lawyers and judges that, as I said, dates back, 200 or 300 years from that point. But beginning around the turn of the 20th century, you sort of see this first wave of efforts to impose greater regulation on economic transactions. And that's restrictions on prices and the more aggressive use of eminent domain, for the service of private businesses, limitations on how businesses can operate, and so forth. And at first, there's a real resistance to that. And that's to be found in cases like Munn versus Illinois, which actually upheld a restriction on price limitations. But what the court said there was, they said the government can regulate private transactions in order to like price restrictions and so forth, as long as the business is affected with a public interest. So that what the court meant by that is they're trying to draw a distinction between an purely private transaction, like at a yard sale when I sell somebody my old TV. Nobody has any business telling me what I can charge for that. On the other hand, the court says something like a grain silo in Chicago, where all of the farmers store their grain. The court says Illinois can pass a law to restrict what the silo owners can charge the farmers because those silos are affected with a public interest. So that's the test that's created in that case in the 1870s. And then that's the first wave of sort of this attempt to compromise between economic freedom and government regulation. The second wave begins really with the New Deal. And in 1934, there's a case called Nebbia versus New York that overturns Munn and gets rid of this affected with a public interest test and creates a much broader scope of government authority, the rational basis test, which says government can regulate private business transactions as long as elected officials might have thought doing so was a good idea. Well, that's basically carte blanche. Then a few years after that, Nebbia, that case was 1934. In 1938, the Supreme Court comes out and says, well, there are some things that we're gonna be a little bit more skeptical about, restrictions on freedom of speech and things like that. We're gonna be a little bit less willing to let government do that. So as a result of the decade of the 1930s, you have this split where the court treats economic freedom as sort of this disfavored right, and by doing so overturns centuries of Anglo-American common law principle. And on the other hand says, but we're going to provide stronger protections to other kinds of rights, for instance, freedom of speech.
And you mentioned the rational basis test, which I don't know how much you've been following the business closures during COVID, but AIER definitely has. And we've noted that the rational basis test is one of the more important tests when it comes to deciding like what business closures are illegal, what are not. And you make a huge point about how the rational basis test, when that test arose, it completely undermined the foundations of economic freedom, mostly because of just how vague it is. So can you explain kind of how that happened, what the legal physics around that are, and why we should be concerned about it?
Yeah, well, so the rational basis test, in theory, is that the government can regulate something, whatever it happens to be, as long as doing so is rationally related to a legitimate government interest. So what that means is, as long as the government is doing something legitimate, then the means by which it chooses to pursue that aim, as long as those are rational, then that's okay under the rational basis test. So it's got these two components: legitimate government interest, what it is that the government's trying to do has to be legitimate, and a rational means of achieving that interest. Now, here's the trivia question I like to ask people. What is a legitimate government interest? The answer is nobody has ever said. The Supreme Court has never told us what a legitimate government interest is. On the contrary, in a 1987 case called Nolan versus California Coastal Commission, they came right out and said, we have never elaborated on what a legitimate government interest is. Now, if you don't know what a legitimate government interest is, obviously it's impossible to determine whether something is rationally related to it. And so this rational basis test turns into this very vague sort of, as long as the legislature might have thought it was okay test. And it gets worse because it doesn't have to be based on the actual facts of the case. The court has also said that under the rational basis test, the judge can kind of invent a hypothetical scenario in which the law would have been constitutional, and then that means the law is constitutional. So assume that this law is passed for reason X, and that's not constitutional. The judge can say, well, yeah, but if the legislature had wanted to achieve Y instead, or Z instead, and this law would accomplish that, that would be okay. Therefore, I will pretend that this law was actually intended to accomplish Y or Z instead of X, and therefore it's constitutional. So in other words, the judge can manufacture post hoc a justification for the law, and that's good enough under the rational basis test. And the court has even said that actual facts are, quote, constitutionally irrelevant, end quote, to the rational basis test. Now, having said that, there are other cases that say the opposite. There's a case called Borden's Farms, for example, and in that case, the court says, look, this rational basis test, it's just a presumption. All it means is that we assume that this law is constitutional unless there's good reason to think otherwise. So you have basically these two competing theories of what rational basis even means. The courts have never attempted really to reconcile those two. And so as a result, when you're litigating under the rational basis test, you're really litigating in a twilight zone where the judge is free to ignore the evidence and in some cases ignore the rules of procedure and simply just assume that the law might have been okay and that's good enough. It turns into a rubber stamp in a lot of cases. It's very frustrating.
And in your book, you make a huge point about how many of the laws that restrict economic freedom that supposedly keep us safe, like maybe antitrust laws or occupational licensing, for example, at the end of the day, all they do is just benefit established corporations and do little for society. So can you explain to the audience, for example, what is occupational licensing, what's the rationale, and why has it not worked as intended?
So licensing in theory is like a permit system. What it means is you're not allowed to engage in some trade or some profession unless you first get government permission. So a license is a permit. And permits of this sort have been around for a very long time in some form or other. You could even say that the medieval guild system was a kind of a permit. And I mentioned Lord Coke in these old 17th century English cases, and those were about these guild systems and whether a person could engage in, for example, making playing cards or being a bricklayer or being an upholsterer. I mean, there's all these cases from the old days on these questions without getting government permission. And those cases said, yes, you have the right to engage in a common occupation like being an upholsterer or a bricklayer without having to get permission from the government first. And so that laid the background for the 18th century and the early 19th century. About the mid 19th century, though, you start really seeing a flourishing of government licensing requirements for different trades and professions. And the US Supreme Court actually, the first case it ever took up on this question about occupational licensing is a case called Dent versus West Virginia about doctor licensing, because that's the easiest example, right? Is would you allow a person to do surgery without first having proven that he went to college and medical school and got the training and all that sort of thing? So that's the easiest example. And the court says, yeah, you can require a license for medical doctors. Well, you know, within a few years, you're talking about licenses for shoe shining, licensing for horseshoeing, and these licensing requirements always take the same form. It's always, well, this is to protect the public against dangerous or incompetent practitioners. It's safer for the public to make sure that a person knows what he's doing before he does the business. Well, and there's always some degree of plausibility to that, right? The problem is that there's already a sufficient protection for the consumer, and that is consumer choice and freedom of competition. Those are the things that actually protect consumers against bad practices by businesses. And there's a tremendous amount of abuse of licensing because those businesses that are already operating can use licensing laws to prevent new competition from entering the market. So you find situations where, you know, the only people who ever complain about a license violation are existing businesses instead of consumers. Cases that we've worked on where when you ask the government, hey, how many times have you received a call from the public about somebody doing this without a license? The answer is 0. It turns out the only people who ever call the cops about an unlicensed business are other businesses that don't want to face fair economic competition. So the result is that licensing turns into a monopoly situation, which, as I said, goes back 400 years or so. That Lord Coke had a line in one of his speeches where he said that people who use licensing laws are like a man rowing a boat. They look one way, but they row another. They pretend public benefit, but intend private benefit. So you often find that situation. Another good example of this is something similar to an occupational licensing law called a certificate of public convenience and necessity, or a certificate of need. These are laws that they don't relate to a person's ability to practice the profession. Instead, they're licensing laws that say you can't operate your business unless you first get permission from all of your existing competitors. So for instance, you can't open a moving company in Kentucky until you first get permission from all the existing moving companies in Kentucky. Well, it turns out that they're not willing to give you permission to compete against them, right? I'm glad to say we brought a lawsuit against that some years ago and won that case, and the court said that that licensing law was unconstitutional because it was just being used to arbitrarily prevent economic competition. But that's a very rare outcome. Usually, as I said before, the courts will uphold these economic regulations in virtually every circumstance.
So this next question, the text got cut out in the email. But the actual full question was, you talk about regulatory takings and how the compensation is becoming more and more inconsistent. So like for the general context for the audience, if the government takes your stuff, it must compensate you for that. And we're specifically talking about regulatory takings right now. And so you talk about how there's a growing faction of people who would like to do away with that. So can you explain to the audience why compensation for takings and specifically regulatory takings are a good thing, especially for limited government and economic freedom, and why some people would like to do away with that?
Yeah, so regulatory taking it's similar to eminent domain. Actually, it's worse than eminent domain, because in eminent domain, the government takes away your property. It takes the title to your land. In regulatory takings, they don't bother to take the title. They just regulate you in such a way that it ruins your ability to use the land. And then they say, but we don't owe you just compensation because we didn't actually physically take the land. And that's a lot cheaper for the government. It's a lot easier for the government. And unfortunately, as I mentioned, the courts, because they've kind of backed away from protecting economic freedom, the courts have created this very confusing mishmash of law as to when a property owner is entitled to compensation when the government takes away your right to use your property. They've basically come up with this touchy-feely balancing test called the Penn Central test, from a case called Penn Central, that says, well, we have these factors that we consider ad hoc. They like to say it's an ad hoc balancing test. Of course, ad hoc means the opposite of law, right? It means arbitrary case-by-case determinations of whether the judge thinks that the legislature has gone too far. That's another phrase that the cases use. If a regulation goes too far, then you're entitled to compensation. What does go too far mean? It basically means whatever the government says it means, and the court has been very reluctant to compensate property owners under this test. In fact, I believe the Supreme Court has never compensated a property owner under the Penn Central test. And this is very timely for us to be talking about this, by the way, because just a few weeks ago, Justice Thomas issued an opinion in a case out of Hawaii where the Supreme Court decided not to hear the case. And he wrote one of these decisions where he says, I think we ought to hear this case. So it's not a binding opinion, but it expresses his views. And he says, look, this law, this entire area of law is so vague that the only thing that is absolutely clear from it is that the property owner always loses. And that can't be the way that the law was written. If people are entitled to just compensation for the government taking their property away, then it ought to compensate them for taking their property away. It should not be a situation where the government can pass a law that leaves you with zero value or, 0.001% value of your land, and then they don't have to pay you for it. There's a case in Rhode Island, so this is about 20 years ago, I think, where called Palazzolo, where the property owner intended to develop some land and build a bunch of condominiums on it. And the state regulated it by imposing a restriction saying you could build one single family home on this land, which was a deprivation of something like 99.9% of the value of the land. And the court says, yeah, but it's just a regulation. It's not an actual seizure. Therefore, the government doesn't have to pay a single dollar to the owner for having wiped out that value. Well, that's obviously unjust. It's obviously not what the Fifth Amendment was intended to allow, but that's the law that we're left with today.
So we've actually been very efficient with time, and I can see that you definitely know how to pack a lot of information into a very concise package. So I'd love to ask one more question. Obviously, that's probably why you work at Goldwater. So I'd like to ask another question that wasn't included. I don't know if this was said in your book, but it's definitely a position that I've heard people like law professors like Randy Barnett at Georgetown talk about, and that's essentially a classical liberal constitutional judicial activism pitch. So I was wondering what's your take on that for the audience, brief context. The courts have essentially shifted so far away from the Constitution that, we can't really have this originalist precedent motive anymore. We need to start pushing back in the other direction. So can you explain briefly why the court has become so progressive, and then why should or should not we have a sort of this constitutional classical liberal activist push for the court?
So the phrase judicial activism is always very contentious, because in a lot of places, judicial activism is just a synonym for the court did something that I don't like. But what people often forget is that so-called judicial restraint is itself a form of activism. And what I mean by that is, a lot of the time, the way that judges implement their own political opinions instead of the law consists not of the court doing something, but of the court refusing to do something. And as a result, the so-called living Constitution very often turns out to be a dead Constitution. It turns out to be a Constitution with all sorts of holes that have been punched in it by judges refusing to enforce what's actually written in the document. The best example of this is Kelo versus New London, the infamous eminent domain case from 2005, where the Constitution of the United States says the government can only take property through eminent domain for public use. Now, we could debate what public use means, but one thing that's absolutely clear is it means the opposite of a private use. But in Kelo, the court said it was okay for the state to take away a person's home and turn it over to a private developer for private profit and private development. That's plainly unconstitutional, and the court nevertheless allowed it to go forward. And when you read the opinion as to why, they say, because we don't want to be judicial activists. It's an act of judicial restraint. We're not going to impose this due process clause because it's a democratic question. The voters should decide, et cetera, et cetera. Well, no. The Constitution puts limits on what voters can decide. And what the court was doing there was refusing to enforce the Constitution in the service of an ideological orientation, which is progressivism. Now, what happened with progressivism is, we're talking about progressivism is a movement that begins around 1900. And a lot of people say it ended in the 1920s, but really it went to sleep in the 20s and reawoke in the 1930s. And what this primarily philosophically, what the progressives did was they replaced liberty with democracy as the central constitutional value. If you read the Constitution's preamble, it talks about why the Constitution exists. And among other things, it exists to secure the blessings of liberty. The word democracy does not appear there. In fact, the word democracy appears nowhere in the Constitution of the United States. The reason for the Constitution is to protect our liberty against democracy. Nevertheless, in the 20s and the 30s, and especially in the 40s, what happened was courts began to emphasize the importance of democracy instead of liberty. In some cases, even saying that liberty is the result of democracy or is created by democracy, which is just a falsehood. And so you end up with cases, like I said, like Kelo, that sort of elevate democracy, or in that case, legislative choice, which is not necessarily the same thing as democracy, over liberty and over individual rights. Now, the question of whether the Constitution is a classical liberal document, the answer is, of course it is. One would have to be willfully blind in ignoring the historical record to pretend that the Constitution is anything other than a classical liberal document that prioritizes individual rights and begins with the premise that all individuals are created equal with fundamental natural rights, that government exists to protect those rights, and that a government that interferes with those rights unduly is unworthy of existing. Nowadays, it's been some decades now, we've had this movement in the historiography to try and recharacterize the American founding as not really being about classical liberalism. This is the theory of classical republicanism, which says, oh, well, John Locke wasn't really that important to the founding fathers. These things are simply false, but they've become very popular nowadays. And that has had ramifications in the law. And so the legal ramifications are things like what is now being called common good constitutionalism and other theories that say, well, no, what's important about the Constitution isn't individual liberty, it's collective choice, which would have come as really quite remarkable news to the men who wrote the Constitution, who fought the revolution, and wrote in the Federalist Papers that the purpose of government is to secure individual rights, not to protect the sovereign authority of states and so forth. So with that in mind, my ultimate answer to your question is there are values, normative moral values embedded in the Constitution, and those values come from the classical liberal background as articulated in the Declaration of Independence. And that's why in my book, The Conscience of the Constitution, I argue that the Declaration of Independence is the conscience of the Constitution and is part of our law. That's another point, that it's become popular among certain quarters to argue that the Declaration of Independence can largely be ignored. Its statements about all people having inherent rights, that's just political rhetoric, blah, blah, blah. Well, no. The Declaration of Independence is as much a part of our law as the Constitution. It is one of the organic laws of the United States, and it is legally binding. So that should guide our interpretation of the Constitution. And when we look for the meaning of things like the word liberty in the Constitution, we need to consult that philosophical framework and not try to impose some 20th century philosophical framework like progressivism, which ends up with us refusing to enforce the Constitution as written.
Tim, you must be an absolute whore to go up against in court. His book, The Right to Earn a Living, it's been published by our friends at the Cato Institute. Tim, I'm so glad that you're on our side, and thanks for hopping on with us.
Thank you so much.
And to our audience, please keep a lookout for our next guest. Thank you.